You so much. And thank you to the Hampton Bays Library and to Donna for having us tonight. Thrilled to be here. Thanks for tuning in at what might be some people's dinner time, maybe a little after dinner time, maybe a little before dinner time. But hopefully we'll get you some good information that you can take with you as you're deciding how to continue on with your own care or the care of a loved one. We are going to be talking about thriving on the East End, but a lot of this information is important and applicable regardless of where you live. I will talk specifically about East End related resources and East End related concerns as we go through. So let's get started. So first of all, as you're aging, the most important thing is to have up-to-date estate planning documents. I have some people come in to meet with me and they say, well, estate planning is just for the really, really rich people. Well, that's not true. Everybody should have certain documents in place to make sure that their wishes are carried out as they age. So for example, a healthcare proxy. A healthcare proxy is a document that says that if you become incapacitated, who will make medical decisions on your behalf? This is an important document for absolutely everyone to have. We do complete this document with clients as part of their estate plan. However, you do not need an attorney to complete this document. A healthcare proxy is a document that requires 2 witnesses over the age of 18 who are not those named in the document as agents. So any 2 people can be witnesses. You don't need a notary and you don't need a lawyer. You should know that your healthcare proxy should name 1 person at a time. So you can't say, I have 2 children and I want them both to be my agent, or my spouse and my child together. They can't act together. You have to list them as a hierarchy, one and then the other. We like people to put their cell phone numbers for the individuals that they're naming on the document so that in case of an emergency, that person can be reached. If you are living in your home on the East End, or anywhere, and you have these healthcare documents, such as the healthcare proxy, you want to make sure that should there be an emergency and you need to call 911, that the document can be found easily by the emergency responders so that it could go with you to the hospital and they can contact the person that you've named as agent if necessary. We often tell people to leave their healthcare proxy either on the back of the front door or on the refrigerator, because those are places that EMTs often look to see if there's important documentation or phone numbers. You should also can keep a copy of your healthcare proxy in your purse if you carry one, with your wallet, so that it is with you when necessary. Along with the healthcare proxy, I'll also add that with the healthcare proxy, we ask that you fill out that your agent knows your wishes regarding artificial nutrition and hydration and can make those type of life-ending or potentially life-ending decisions for you. So it's not enough to just name your agent. You also have to state that that agent can act on your behalf in terms of those end-of-life decisions. The healthcare proxy, you can also allow for organ and tissue donation if you choose to. The living will is a document that goes along with the healthcare proxy. And in general, it says, if I'm in an irreversible state with no reasonable expectation of recovery, then I'm allowing my agent to withdraw or withhold treatment. So to withdraw or withhold any life-sustaining measures to keep me comfortable, to give me medications to keep me out of pain, even if those medications might hasten my death. This is the kind of document that we like people to have because it gives a general statement of what you would want in this type of life-ending time. We often put in the healthcare proxy and living will document when we draft them in our office that it is the individual's wish to live out their days at their home rather than in a facility. So if you are looking to live in your home, to stay in your home, and to die in your home, it's important that your documents reflect that and that the agents that you're naming know that that is your strong desire. And that way they can do what is necessary to keep you the way you want to be kept at the end of life. We also often sign a HIPAA release form, which is a form that allows for your medical information to be released to the people you name on the form. So the healthcare proxy is only in effect if you're deemed incapacitated, but you might not be deemed incapacitated, but you might want loved ones, family members, friends to have access to health information, and you can do so through a HIPAA release form. HIPAA is the law that allows you for privacy over your medical records. Beyond the healthcare documents, I recommend everybody have a power of attorney. Now, not all powers of attorney are created equal. The power of attorney document gives the agent in the document whatever power the document says. So you can do a very limited power of attorney that only allows your agent to maybe conduct banking transactions, to pay bills, or you can do a much more extensive power of attorney that allows your agent to create trusts, move money around, move money into your name, out of your name, change titling on accounts, change beneficiaries. And what you decide to put in that document should be done with the advice of an attorney to determine what is the best in your circumstance. But no matter what power you're giving and no matter who you're giving it to, the most important thing is that you trust the person that you're naming as agent under the power of attorney. Because if you don't trust them, you should not be naming them, because you are giving large authority to give away your assets, to access your assets, and you don't want to find yourself to be taken advantage of because you've named somebody that was not trustworthy. So it's important to trust the person that you're naming in that power of attorney document. Your power of attorney also will say who's the successor. So I might name one person to act as my power of attorney and then someone else to act if they're unable to do so. Or I might name two agents that can act together. And everybody's situation, again, is going to be different. I usually caution against naming more than two agents to act together. You know, once we get into 3 or 4, the logistical issues can be very difficult. But that's something you should discuss with your attorney. If you have a power of attorney from before June of this year, you have one of the old forms under the old law. In June of this year, the power of attorney law, the new power of attorney law that was signed this past December, came into effect. One of the main changes in this document was that now for your power of attorney, there is no what we call statutory gifts rider. If you want your agent to be able to open trusts, move money in and out of trusts, we're going to talk about some Medicaid planning in a little bit, which might be necessary to have the gift rider. Your old power of attorney had a gift rider. Your new power of attorney is just one document. It doesn't have a rider for gifting, but it has specific gifting powers. It's important that your power of attorney was valid at the time it was signed. And it's okay if you signed a power of attorney a year, 2 years, 3 years ago, as long as it was valid at the time it was signed, and as long as it gives all the powers that you would want or potentially need your agent to have, it's still a valid document and you don't necessarily have to update it. However, if you have a power of attorney from before 2010, I'm just going to flat out say that you should update that power of attorney, because that was the last time there were pretty major changes in the law. 2009, 2010 were the last 2 laws for power of attorney, and anything before that time should be redone and updated because it likely does not give the authority to your agent that you intended to give. And so that's an important change to know about. So again, anything before this past June is still valid if it was valid when it was signed, but you might want to have it reviewed by an attorney to see if there are any updates that are necessary. After June, you should not have a power of attorney with a statutory gifts rider. You should just have a power of attorney that includes specific gifting powers. A power of attorney has to be notarized and has to have 2 witnesses. One of the witnesses can also be the notary. While you don't need an attorney present when you sign a power of attorney document, I do recommend, and the state also recommends, that you review the document and that you review the process with an attorney and make the decision of who to name with an attorney so that you can fully understand what you're signing, what power you're conferring on another person, and what the potential downsides are of doing so. especially in your specific situation. So again, while you don't need a power of attorney to be witnessed by a lawyer, you should consult with a lawyer when completing a power of attorney. And I would recommend having the power of attorney done by a lawyer to make sure you're not putting yourself in a situation where you didn't realize the type of authority that you were giving to another person. These are all still estate planning documents, right? So most people think estate planning is after death. We haven't talked about death yet, right? We talked about the healthcare documents leading up to death. We talked about the power of attorney so that your assets can be controlled or accessed by someone else while you're alive. Those are documents while you're living, and we still consider them estate planning documents. The other documents that we often talk to people about are wills and trusts. These are documents where we're partially concerned with a will, certainly about what happens with your assets after you die. A trust is kind of a hybrid between the two categories, because you can create a trust while you are alive. You can put assets in it while you are alive. It will be managed according to the terms of the trust document while you are alive. But it also says what should happen to those assets upon your death, just like a last will and testament would do. And a last will and testament is a document that says how your assets should be distributed after your death. And we're only talking about assets that are in your sole name with no beneficiary. So if you have a beneficiary designated and it differs from the beneficiary you list in your will, the beneficiary designation will win out. And the person that you've named in your will is not going to receive that asset. Same with a joint owner. If you have a joint owner, that joint owner will own whatever that property is upon your death. And that's if it's joint with right of survivorship. Often we get into with clients somebody who is looking to receive home care Medicaid. And that's a lot of what we're going to talk about from this point forward today. Home care Medicaid is a program by which, if you financially are approved, the Medicaid program of New York State will provide you with services in your home for long-term care, including home health aides. Now, there are specific challenges to staffing the cases when we're on the East End that I'm going to cover in a few minutes, but just talking strictly from a financial standpoint at this time, if you have less than $15,900 in your name, you can apply for Medicaid. In addition to that $15,900, you can have tax deferred retirement accounts. So if you have a 401k, an IRA, 403b, these are valid assets that you can have over and above the $15,900. You have to be taking distributions from those accounts, which makes them a stream of income rather than an asset, but you can still be eligible. Very importantly, if you are living out on the East End or anywhere in New York State, but specifically we're talking about the East End, and you own your home, and the equity value of your home, so if you have a mortgage, that would come off of the value of the home, but the equity value in your home, it's under the Medicaid limit, then you can apply for Medicaid even when you own your home, and you would be eligible. The equity limit is between $900,000 and $1 million, and it will go up again in January. Everything goes up incrementally by a small amount each calendar year. So let's say you have a home that's worth $800,000. You can apply for Medicaid and you will receive services. But it's very important that you realize that if you own that home in your own name, when you die, if you didn't do any additional planning, Medicaid is going to have a lien on that property if it's in your sole name, because it will have to pass through the probate of your will, and therefore Medicaid has a lien. So if you own your home, even if it's exempt for eligibility purposes, I urge you to see a lawyer to look into transferring that home, probably to some type of trust, so that upon your death, it's not in your sole name, it does not go through probate, and therefore Medicaid doesn't have a lien on it. Because there's a difference between what Medicaid, what you can have to be eligible, and what they can claw back after your death. So again, I don't want you to get confused by the fact that people say you're allowed to have a primary residence in your name, because the issue could happen after your death. And you don't want to make that mistake, because then your intended beneficiaries aren't going to receive the full property because there will be a lien on your estate. If you have assets that are above the $15,900 in your name, let's say it's a cash, or perhaps your home on the East End is not your primary residence, it's a secondary residence, you might need to take those additional assets and put them into what we call an irrevocable trust for Medicaid asset protection. That trust can say that you receive all income generated from the assets in the trust, but you can't receive principal from the trust. This is important because if drafted properly, you can have the assets in the trust, they can pass to your intended beneficiaries on your death, but you can still apply for that home care Medicaid. And after 5 years of being in the trust, you could apply for nursing home Medicaid if that becomes necessary. So it's important to get this advice on your individual level. And I'm going to keep saying that over and over again, because nothing beats the information we're giving you today is educational. It's informational. It's there to trigger something in your brain to make you think, I should speak with my lawyer and I should figure out if this makes sense for me. And it may or it may not. But you really need to be thinking about, what should I be doing to plan forward? Now, for a nursing home, there's a 5-year look back. What that means is if you apply for Medicaid to pay for the cost of your nursing home, they go back 5 years, they see what did you give away in those 5 years, not what you paid for. If you spent it all on yourself, that's fine. But if you gave gifts, you gave away to a trust, you gave away to a family member, a charity, they assess a penalty. And so they may say, well, for every, it's about $13,500 that you've given away, you get a 1-month penalty. We don't currently have that look back for home care Medicaid in New York State. The law was written in to change that, to put in a 2.5-year look back for community Medicaid. So saying you can't apply for community Medicaid unless you didn't give things away for the last 2.5 years. But that is not currently law in New York. It will not go into law definitely before April 1st, likely not before July 1st, if ever, because we need the federal government to approve that change in the law that New York State's trying to do. So you have to check back to see if this has changed, because it's just day to day. We wait to see if anything's going to happen. But we know that this is not going to be implemented before spring or summer of 2022. So for individuals who are applying now for Medicaid home care services, if they are eligible on the 1st of the month, they can apply for Medicaid. So if your assets were transferred on November 30th and they cleared by the close of business, then on December 1st, you are eligible for Medicaid and can apply for services. It's important to do the trust planning with your home, because a lot of people on the East End may have bought a property many years ago for a very low price. So say you live, I'll say you live in Hampton Bays, and in the 60s, you bought your property for $20,000. And now your property is worth $2 million. And that's not an uncommon thing out there. We see it in other parts of downstate New York too, but on the East End, it's really a big difference in the way that these prices have jumped, especially for those of you who might have purchased your property in the 50s, 60s, 70s, even 80s in a place like Hampton Bays. So you want to make sure that upon your death, when that asset is inherited by your family member, that they get what's called a step up in basis. This is incredibly important to those of you who have properties like I'm describing that are on the East End that have jumped in value. And you want to make sure that there's not an enormous capital gains tax paid when your loved ones who you leave behind sell the property. So if you purchase the property at $20,000, maybe you've put capital improvements into it of $40,000. Well, then your tax basis while you're alive is $60,000. So you have what you purchased it for plus the capital improvements. If it's worth $2 million and you sell it while you're alive, you're going to pay a capital gains tax on the difference between that $2 million and the $60,000. That's a very large tax. Whereas if you hold on to it and upon your death, you either own it in your name, or like I said, for Medicaid, we don't want you to own it in your own name. You've put it in a properly drafted trust. Then it could be protected for Medicaid purposes, and your family can get that step up to your date of death value. So if at your death, it's worth $2 million and they turn around and sell it for $2 million, there is no gain and no capital gains tax. So it's really important when you're living somewhere like on the East End, where the property values have jumped so high. Even, I mean, let's face it, even in the last year, people are seeing jumps in their property values. You could really be doing a disservice to your family members by giving them the property while they're alive. I had a client who came to me a few years ago and they said, I'm here because I need a deed. And I said, okay, that's the answer. Let's slow down. Let's see, what's the problem? Well, I'm worried that my property that I purchased for a really low price, that's worth a lot of money right now, I'm worried that it's going to keep me from getting Medicaid services. And I want to keep living there and I want it to be my property while I'm alive, but I don't have the liquidity in cash or in income to pay for what long-term care services would cost. So I want to be able to protect that property, but also, do what makes sense. So I want to give the property to my son. And I said, okay, let's slow down. Your problem is Medicaid, and if you give that property to your son just outright while you're still alive, he's forever going to have your low tax basis, that $60,000 tax basis. And so when your son, long after you're gone, your son turns around and sells the property, he's going to pay a huge capital gains tax. Whereas if you took the property and put it in a trust now, we could protect you for Medicaid, which is your main concern. And we can make it so that your son gets that step up and he's not paying a huge capital gains tax unnecessarily down the line. Also, you want the property to be in control of the parent in this instance, because they might get a veteran's exemption on their real estate taxes. They might get a senior citizen's exemption. All of those property tax exemptions that's personal to the individual won't be lost if the trust is drafted properly, but it will be lost if you give that property to your son while you're still alive. So we've protected for Medicaid, we've protected for real estate taxes, and we've protected against the capital gains tax, and managed to still get the property to the intended person at the death of the individual. So this is really an important planning tool that you should know about if you do own a property. I'm going to stop for a second because I see a question came in. So I'm going to take a pause. So this person asks, what happens if you own a co-op for your dependents and it's in your name upon your death? So a co-op, the rules would apply just the same as any other asset. If your co-op, if your house, if your bank account is in your sole name at the time of your death, then it has to go through the probate process. And if you have a will, and then it will go to the people you've named in your will. If you don't have a will, then it goes through something called administration, which is a similar process with the courts, but then your property goes to your legal next of kin. And so you really want to avoid that administration. You really want to know. If your probate is in a county like New York County or Kings County or Queens County, and as I said, we have a lot of clients who split their time between Manhattan or a different borough of the city and out east. Your will is probated in your place of primary residence. And in those New York City counties right now, probate is really slowed down ever since COVID. For some of our clients, it's taking 8 months, a year, maybe more for probate to be completed. And your property generally sits dormant that time, and somebody has to pay the fees for maintaining the property. And so we want to avoid that. So we really are trying to tell people that avoiding probate is important. It's also important, again, because if you go on Medicaid, Medicaid can put a lien on that estate if it goes through probate. So in my example, someone is at home on the East End and they're applying for home care Medicaid. The other thing I wanted to point out about the importance of the property being in the trust as opposed to just giving it away is that in order to be at home on home care Medicaid, we have to segregate what Medicaid refers to as excess income. That's income over Medicaid's allowable limit. We segregate that into a special account called a pooled income trust. And it can be used to pay your bills, but it can't be used to pay bills that aren't in your name. So for example, if your house was given to your son, you can't use your income to pay the property taxes on that house. And so you don't want to give away the asset, lose control of it, and then lose the ability to use your own income to pay for it. So that's another reason why it's important to do this type of trust planning. So for the individual who is on the East End and who is applying for Medicaid, our big problem is staffing. This is a problem everywhere in the state right now that was made worse by COVID. The ability to get a caregiver into the home to fill the hours has been hard and made worse by mandates from the state, which came into effect in October, that all home health aid workers licensed home health aides must be COVID vaccinated. And so that has made it even harder. We've always had this problem on the East End though, so it's only just gotten worse. So let's say, for example, Medicaid says you are financially approved and you're going to segregate your income the way we tell you to. And we come in and we have a nurse do an assessment, and the Medicaid nurse says we're going to give you 8 hours a day of home care. The problem becomes finding someone to come and work for those 8 hours. 8 hours is a little bit better than, say, 4 hours. It's very hard to staff a shift for 4 hours, especially in a more remote place, because by the time the home health aide gets there, they've spent so much time traveling, and there are transportation issues on the East End. We all know there's traffic on the East End. And so that can be a big thing for the aide to get there and then only work for 4 hours. So it's very hard to staff low-level cases. And even on the higher level cases, we find it's taking a very long time to get the care in place and to actually staff it. A really important program in places like the East End of Long Island is called CDPP, the Consumer Directed Personal Assistance Program. This is a Medicaid program where, rather than having a home health agency staff the case with their own workers, you can have individuals that you know, friends, family, community members, someone that a friend knew, come and work in your home, fill your hours, be your caregiver, but be paid through the Medicaid program. So take my same example of the individual who went through the whole process and got 8 hours a day of care. Their son, daughter, neighbor, person from the church or the temple, the aide who helped someone else that they know who's now doesn't have enough hours and can start working, they can actually be signed up as the caregiver. They don't have to be a licensed home health aide, but they have to be able and willing to be paid on the books in New York, in the United States. They sign up with what we call a fiscal intermediary, and they are paid to be the Medicaid caregiver. This program is crucial for those who are on the East End or in more remote places that are hard to staff. And I believe someone's asking me to repeat the name of that program. It's the Consumer Directed Personal Assistance Program. We call it CDPP. CDPP is how we refer to it. And this is a really great thing for those who are staying at home. And, you may have a family member who's given up their job where they could earn a living in order to be the caregiver, and they can be paid through the Medicaid program. So it's really, really great. There was a question, do the CDPP aides have to be vaccinated? I don't think they have to be, because they are not a licensed home health aide. So they're not under the control of the Department of Health. I haven't looked into that specifically, but I don't believe they have to be. The CDPP program is a really great program. It's really, really helpful to our clients who are trying to staff a case. And so that's definitely something that I would recommend looking into if you are living in a more remote place. The other really good thing about a CDPP caregiver is that they can do things that a licensed home health aide can't do. So for example, feeding tube, administering medications. A licensed home health aide actually is not able to do those things, whereas an unlicensed CDPP caregiver can be trained and can provide those functions. And so that's really, really helpful for those who need the assistance with something like medications. A licensed home health aide can take, the Monday cup and take the water cup and put it in front of someone and say, okay, take your pre-poured, your pre-packaged pills now. But that aide can't actually administer the medications or handle the medications, and that's a licensing issue. So again, the CDPP program, I think it's crucial to getting care and staying in your home on the East End. And so, it's good. You take a look around as you're starting to prepare maybe to get to this point and think, who are the people around me who may fall into this category? Maybe it's a friend who's, a little bit younger, 10 years younger, 5 years younger. This program was made for the family caregivers who were giving up their careers or their jobs, and the informal caregivers that come by. Some people say, oh, the nice woman from the block was coming by once a week, and then it was twice a week, and then it was 3 times a week. And now all of a sudden this woman has a full-time job, and she never even realized that was about to happen. She was just helping out. Well, it's a lot easier and a lot better for her. She can help out and be paid to do so. And that really helps the individual more. Some other than that, and I'm going to stay on and answer any questions, but I just also wanted to talk about some resources that we're aware of in our office on the East End. And I'm sure there's many more than this, but I just wanted to throw them out there just so people have an idea of where to look. So on the North Fork in Greenport, there's what's called a NORC, a naturally occurring retirement community. We have several of them in the city, but this is I believe the largest growing area of aging adults. And so they get special state funding for services. And this is run through the Family Service League. So the Greenport NORC. In Hampton Bays, the town of Southampton runs a day program that's excellent. And so looking into the town of Southampton and the supports that they give for the elderly is a really great place to start if you are looking for supports in the community. In Riverhead, Northwell has the Peconic Bay Caregiver Center, which is a fantastic resource, and they do a lot of really great programming and provide great information for individuals who are aging on the East End. The Alzheimer's Association has a Riverhead office. The Alzheimer's Disease and Resource Center has a satellite office in Southampton. East End Hospice is a fantastic resource, and the Canis Center provides, which is in West Hampton, provides social workers and counseling for those who are dealing with end-of-life issues. And then there are multiple home health agencies on the East End, some of which have Medicaid covered caregivers, but many of which who are also private pay caregivers. And so that, a lot of what I talked about today is Medicaid. However, you can pay privately for care. And if you have long-term care insurance or the assets to pay for that care or the income to pay for that care, you can go through these great home care agencies that are on the East End and have them be paid in that way privately rather than through the Medicaid program. So I'll just stay on for a minute and answer any questions that anyone has. I think I've answered all the ones that are up there now, but feel free to write in and I'll just wait. It's interesting, you know, I'll just mention as we're waiting to see if other questions come in. As an attorney who has a lot of clients in Manhattan and also has a lot of clients on the East End, you know, we have offices, 2 offices out in the Hamptons. I have a lot of clients that not just because of COVID, but really as they've aged, some of them have said, you know, it's a lot easier for me to be out East at my place out East. I can get in and out of the car. I have a walk up in the city, whatever it may be. And then I have a lot of clients who say, oh, it's much easier in the city. I can get everything delivered. Everything's right there. So it's really been interesting for me working in both places to see what services are available in both places and where people choose to age. If you and your spouse own a home jointly, do you still need a trust? So you may still need a trust. You may or may not. There's a lot of factors that go into it. There's also a lot of different types of trusts. I only really covered the Medicaid trust today, but there's other reasons to do trusts and other types of trusts. The issue with owning the home jointly with the spouse is when the first spouse dies, the second spouse inherits the home, and that's not generally an issue. The problem becomes when the second spouse dies, then there's a probate situation. And is that going to be a big deal? And some people say, well, we'll deal with it when the first person dies. But the problem is, what happens if the first person dies and the second person forgot they were supposed to deal with it, or they have some cognitive impairments, or they die soon thereafter and they didn't get around to getting their estate planning done? You want to make sure that you're covering all bases. So there are many cases where we recommend that spouses that own a home jointly still do a trust. Okay, let's see the next question. So it asks the rate of compensation for the CDPP program. It's usually on the East End, I would say across from the city out to the East End, I would say it's usually somewhere between like around, give or take, $16 an hour on the books for the CDPP caregiver. But a spouse cannot qualify because a spouse is a legally responsible relative. So the program won't pay the spouse to be the caregiver, but it will pay other family members. I think some places it's $17 an hour, and every fiscal intermediary has a fee, but again, it's usually between, I would say, plus or minus $1 from 16. Any other questions? All right, I think we might be done here, Donna.
Thank you so much. Lots of very useful and important information. Thank you.
Thank you. My pleasure. Have a great night.